Thank you, Mr. Chairman. And I know we're gonna, are you gonna have a second panel at some point in time?
We do have a second panel, right after your questions are finished.
Okay. Well, I almost wish Mr. Meltz could join us now from the CRS. I'll wait, but because Mr. Pirelli, his testimony seems to be a little different than yours on this issue of retroactivity. And the reason why I'm interested in this, I think, is like millions of Americans, we want to know who's going to clean this up and how we're going to pay for it, and to make sure that the taxpayer doesn't become the deep pocket on this, and that we also don't wait 20 years, as we did with the Exxon Valdez case. But in his testimony on retroactivity, he basically says the Constitution disfavors retroactivity. At least 5 constitutional provisions noted above basically make it very hard to go back and do retroactivity. So you seem much more confident.
And I read Mr. Meltz's testimony, and I actually think it is more consistent. While he starts from the proposition, and I quote, that the Constitution disfavors retroactivity, as I indicated, Congress legislates retroactively all the time, and particularly in a context where there's an important public policy purpose at issue, Congress is legislating in a rational way to try and address potential compensation and cleanup for victims in a statute that is not penal in any way, and covers a broad range of whether it's past and future activities. We think we have strong arguments that if Congress decided to legislate retroactively, that it would be upheld as constitutionally.
In the Oil Spill Liability Trust Fund or someplace else?
I'm not sure.
How would you legislate? The discussions have been changing the Oil Spill Liability Trust Fund, taking off the cap,
removal
things
of
of that nature to make it retroactive. And again, I'm all for them paying. What I don't want is to hear today, oh, there's this simple answer. I don't want to hear just like when they were here a few weeks ago and they were saying, we're going to pay all legitimate claims. And then I read a list and they start going, oh, well, I don't know about that one, or yes or no. And so I don't want to hear today, oh, we have great hope and promise in retroactivity, only to find out it takes us 25 years to get anywhere on that case. And in the meantime, there's significant damage that's not dealt with. So he basically says that on these 5 different issues here, that 3 of them, basically, he says, appear to have modest chance of success, and 2 of them seem to have almost no chance of success. Those are those constitutional issues. Mm-hmm. And so you're thinking of something different?
Senator, I think that our view is that we would have a strong chance to defeat any constitutional claims if the Congress were to lift the caps. So I may ballpark the chances a little bit differently, but I think fundamentally, like as I indicated, Congress legislates retroactively quite frequently, and so we don't think that would be an issue. As Mr. Meltz noted, and as I noted before, I do think there certainly is the potential for a breach of contract action, but OPA itself expressly says and puts everyone on notice that Congress has reserved the right to increase penalties or increase removal costs or damages and increase the liability or impose additional requirements. So I think that's clear to everyone in the industry.
But it doesn't say retroactively.
It doesn't say retroactively, but as I indicated, I think we believe that we have strong arguments to defeat any retroactivity argument that would be made.
Thank you for your clarity. Do you think that we should also look at, since BP has had something like 373 million in fines and restitution for environmental violations, a Texas refinery in an explosion in 2005, a leak from a crude oil pipe in Alaska, fraud for conspiring to corner the market and manipulation of propane. Do you think that there should be some sort of 3 strikes you're out kind of clause as it relates to companies doing business that maybe you wouldn't allow them to continue to bid on new leases?
Senator, we'd be open to that, certainly. I mean, there are other examples in other environmental laws of situations where companies are, because of a pattern of behavior, are, for example, not allowed to have federal contracts, that sort of thing. So we're absolutely open to that. I think we're very interested in seeing these investigations run to ground and not prematurely drawing conclusions, but we do intend to look at those issues.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Isn't one reason why we need the Oil Spill Liability Trust Fund is that we don't always know who's responsible for the spill? And so you want somebody cleaning up the spill even before you determine liability.
Absolutely. That's one of the primary purposes of the fund, to have this access to immediate funds for federal response.
We've had that unfortunate situation in Puget Sound, so that's why I bring that up. Mr. Meltz, if Congress tries retroactivity or a higher liability limit to the Deepwater Horizon spill, would you say that it's nearly certain its constitutionality would be challenged in court?
I would imagine that given the broadness of many constitutional principles, and given that different judges of different ideological stripes take different views of the breadth of constitutional protections, it might very well be worth their while to consider a challenge.
And if that's the case, that it is this legal gray area, wouldn't it take years to resolve through the court system?
It certainly could, yes. I think, initially you'd probably have a trial court decision, I think, saying it's constitutional, and then it would go up through appeal and possibly to the Supreme Court. So it's a little hard to predict how many years that full spectrum of procedures could take.
Well, if we look at the Exxon Valdez, it took 20, so that's an idea. So, thank you, Mr. Chairman.